Yeah, here we go. So first of all, thank you, Igor, for the introduction. And Livia and I was preparing this presentation a few days ago, and we're seeing how Igor is managed to put things together, so kind to us. So thank you for that. And yeah, I keep coming back to this occasion.
I'm sorry that she couldn't come. She planned to come, but
yeah. In a way, most of you have witnessed my growth, like my enthusiasm with salvage law. Last year, I really thought it was the last time for me for a while to present something about salvage. But thanks to Livia, who came to me a couple months ago after her event on art law in cinema, she said to me, Haiyang, there's a new case by ECHR. They find a Greek bronze this Victoria used is from the ocean, and Italians think it's their property because it was found by Italian fishermen. The flag of the vessel was Italian. Let's do something together. So here we are. Let's see. So first, yes. So first, I would like to start with introduce some basic facts about this interesting case. Actually, this sculpture was found in 1964, quite a long time. It was put from the Adriatic Sea by Italian fishermen and then privately sold without reporting to the authorities. Back then, Italy already has national law that if you find something in the ocean, it's cultural property, you have to report to us. But fishermen didn't do that. They secretly sold it out. In 1977, the Getty Museum from United States, they managed to purchase this sculpture from art dealer in Munich. And for since then, the sculpture is still there. Italian court keeps trying to take it back to Italy. They even issue a confiscation order for violation of an export ban, because, as I just mentioned, in Italy they have a national law in place already. If you find something, the ownership belongs to the state. Then earlier this year, ECHR made a judgment, quite interesting, that they find this confiscation order from Italy does not violate Getty Museum's peaceful procession of the statue. And now here we are. The judgment is here. Whether the United States will court in the United States will recognize this, we'll wait we will find out later. And with this case in mind, we want to address the obvious issue of underprotection of underwater cultural heritage, and especially for those located in international waters. We will analyze this based on this Getty case. So we look into Italian legislation and US legislation in this regard. And a leading author in art law named O'Keefe, who identified 3 key issues in protection of cultural heritage. And we will focus on who has the jurisdiction and who has the ownership in order to protect underwater cultural heritage. First, we have a look at international law level. We have UNCLOS, and we all know that it doesn't really impose concrete obligations on states, even though there are 2 provisions related to the protection of underwater cultural heritage. They also have this principle of saying that any artifacts found on seabed should benefit all humankind. But from UNCLOS perspective, it's more symbolic, in my opinion. And if you look at cultural heritage conventions, the top 3, they are the main legislation, main conventions in cultural heritage, but they don't mention protection of underwater cultural heritage. And they have the limitations to territorial waters, and there's no retroactive effect, meaning that before those conventions, whatever happened, you cannot go to the convention to protect underwater cultural heritage. And many of you may remember we do have 23 years ago, we do have a special convention, UNESCO convention on underwater cultural heritage, but it is obviously not working. The idea of that convention was basically preventing treasure hunters from damaging all those shipwrecks, because obviously they would only focus on what is valuable, commercially valuable. And for archaeologists, they hate them because they will destroy the shipwrecks, and for them it's such a loss. Also for humankind, think of Titanic. I remember this one scene at the end, like there's a Louis Vuitton bag. Maybe it's still there, but it probably doesn't have commercial value. But it would be very interesting, and maybe it's also a good commercial for Louis Vuitton. But there are many things that doesn't have commercial value, but for archaeologists, for humankind, there are so many histories deserve to be protected. And that's the idea of cultural heritage, and why art law researchers like Livia, they hate maritime law, salvage, etc., etc. And I also want to point out, for the cultural heritage, for the UNESCO Convention, the United States is not part of it. In art law, there's a concept of nations, meaning where the cultural heritage will originally belong to. And there's also market countries, market nations, where all the museums are, where the dealership, where the dealing is happening. And the United States is one of those market nation. No surprising. Yes, also it's a common law jurisdiction, as we know. And that brings us to the next point on the national level. The core issue here, as mentioned, is the tension between cultural heritage law and maritime law. Because if we look at cultural heritage law, take Italy, for example, the national court, they want to protect underwater cultural heritage. They actually have legislation and court decision that gives ownership to the state of underwater cultural heritage. United States, they have this abandoned shipwreck act of 1988. It doesn't really directly saying that the ownership belongs found in international waters of underwater cultural heritage belongs to the state, but rather they deal with the federal government and state government relationship. They gave federal government the ownership of those underwater cultural heritage found in their state waters, and they are silent regarding underwater cultural heritage ownership that is located beyond territorial waters. And now, bearing in mind, cultural heritage law is very much trying to give state ownership to protect cultural heritage, we can move on to the maritime law perspective. And it's about salvage, it's about law of fines. Basically, it's about finding the property that are lost in the ocean. Just to revisit, the law of salvage is basically providing that for the sailor who successfully saved the vessel is entitled to a reward based on the salved property. And the law of fines is somewhat different. It gives the title of the founded property to the finder. I would prefer to call it finder because I don't think it's confusing to call them silver. The economic rationales is also helpful in order to understand. Professor Eric Erikson, he actually used cursorium the other day. And the idea is, in ideal markets, in ideal cases where everyone can simply deal with each other, can negotiate with each other, the magic power of market can solve everything, irrespective of the original allocation of property rights. So in the end, the market can make sure everyone is happy. there will be efficient allocation of resources. It might be too much, but I know. For salvage law, the purpose of salvage reward is basically to simulate the outcomes and conditions of a competitive market that didn't exist because it was an emergency. There's no time to negotiate. The market couldn't work. And then salvage law provides a reward. And if you have any dispute, you can settle during arbitration. In that way, it actually works out. It actually simulates salvage reward, simulates outcome and of a competitive market that didn't exist because it was an emergency. But the whole idea is salvage rewards has commercial value. If you talk about environmental salvage or historical salvage, the value is not about it's not commercial value. It's historical value, it's for protection of the environment, etc. That's from economic analysis perspective, maritime law is at odds to protect historical cultural heritage located in international waters. So now all those treasure hunters, they will go there. They only take whatever has commercial value and get out, ask for money from that. They wouldn't care anything about a shipwreck or broken Louis Vuitton bag, which was nothing for them. So there's a tension between these two branches of law. And how can we find a way forward? So we look to the Getty case. Basically, what Italian court did was to extend the jurisdiction so that cultural heritage law can apply to those underwater cultural heritage founded in international waters. The argument was law and law of the sea. The fishermen's vessel was flying Italian flag. As such, it falls under jurisdiction of Italian court. Whether this makes sense, I invite you, especially we have so many UNCLOS experts in this room, I invite you to have a debate because personally I think this is quite interesting. And of course, the problem is whether the United States, their court will actually recognize this judgment, whether they will have practical implications. This we have to wait for them to, if they even have a reaction over this judgment. And second part solution for is actually my idea. I still very much love the idea of salvage law, and I hope it can work. And with economic thinking, if they don't have commercial value, just give them commercial value. For example, the shipwreck doesn't have commercial value, but if the seller can take videos of it and sell the video, whether to make video games or to make documentary themselves for commercial returns. But of course, that's very ideal. You have to have a reporting mechanism to make sure they will do things as they promised. They will take into consideration of the archaeologist plans. And we have to have a monitoring mechanism to make sure they actually do that. But if you think about it, we are asking the sellers to monitor themselves because they are the only person who can actually have the capacity to go there. So in that sense, yeah, it's quite difficult. And I think that's probably explains why the 2001 UNESCO Convention failed to do that, because that convention was trying to introducing a reporting mechanism to make sure user group, they actually collaborate, and they are not really working. With that in mind, Getty case really has something special to offer, and we hope for the best. And also, I also want to briefly mention, as Arf already gave us this wonderful update about maritime casualty cases. If this shipwreck or the sunken vessel was state-owned, then of course this state immunity is a different story. And the solution might be we have to rely on bilateral or multilateral agreements between the states to protect those sunken shipwrecks. To conclude, what we learned from Getty case is to protect underwater cultural heritage. It gives us thinking. It makes us think that maybe what we need is not an international convention, but to find a way to let the national courts to extend their jurisdiction to protect those cultural heritage, the shipwrecks found in international waters. And with this, I conclude my presentation. And Livia also said she would be very happy to answer any questions that you may have. Thank you.
Thank you very much, Haiyang.
Yeah.
Are there any questions concerning this interesting topic?
I have got clarification.
Yes.
Do I understand that it was found in international waters and caught in fishing nets by accident, and now it's found its way to the Getty Museum in the United States, and it's gone before courts in Italy, and Italy has made a judgment, a declarative judgment that it is Italian property, and now are seeking recovery.
Yes, it's actually quite controversial because nobody has any evidence, any proof to say that was found in international waters. That's how they claim. Like the Italian court basically said the vessel was flying Italian flag. That's why they have jurisdiction.
So the fishing vessel was registered in Italy. And what is the justification for the Italian judgment? How are they claiming legitimacy to make that judgment on the assumption that this is an international?
They say it's a customary international law. They have zero explanation, and this is a point I feel very. They don't give any explanation over this point. So as a maritime lawyer, I really don't think this is very solid argument.
I find it fascinating, somewhat ironic. I can't imagine it being any safer anyway, other than in the Getty. It's probably protected from there. Anyway, I thoroughly enjoyed it.
Yeah.
If it happened today, in the meantime, it depends whether they found it in territorial sea, as you say. But let's suppose that they did find it in high seas. In the meantime, Italy has proclaimed exclusive economic zone in the Adriatic, Croatia too. Croatia is a party to the UNESCO 2001 convention.
Yeah.
So in these conditions, it would be protected, right?
Yeah.
Do you have any other situations in the world that underwater heritage, maybe Livia will know, was taken from somebody's exclusive economic zone, seabed? And what was the legal situation after that?
That's I'm not aware of. Let's actually find others if the EU that.
Because with these 200 miles, these, as you call them, salvage hunters or treasure hunters, actually are losing much of their ground where they could do it, without any repercussions.
Yeah.
And the other question is, do you see it possible to, I don't know, protect this heritage in the high seas, in making these hunters to level them same as, I don't know, drug smugglers, piracy, illegal emissions, illegal broadcasting, human trafficking, so all these international crimes. So because the idea is not to have high seas as an area where, international crime, where anybody could do any acts without sanctions. So, yeah, any place on this, even in the United States, there's always on, I don't know, International Space Station or whatever, moon, some country must have jurisdiction for a crime of murder, let's say, okay?
Yeah.
So, how to extend these rules on high seas, and how to implement them in exclusive economic zone? Do you have any ideas? I mean, having researched this area, you or Livia?
Yeah. I'd say that it's something for
the research.
Yes.
Okay.
But it's the unfair, these were innocent fishermen.
Yeah.
I take it, who came across this by accident. I don't think they fall in any of your categories. And it's, I mean, they're findings. I mean, in a sense, they're sound thoughts. And there's an interesting question of ownership. I mean, if you recover property after a very long time, can anybody claim ownership? And very often, lost property along the sea has been the subject of insurance compensation. I mean, and under rights of subrogation. And all these questions being asked about the Titanic, the aspects that which is not realistic. So I mean, I think it's fascinating that it is an area which requires some serious research.
Yeah.
And if I may quiz you a little beyond your boundaries, if I'm being unfair, you tell me. But I mean, the United States somehow or other has jurisdiction for Titanic.
Yeah.
Because they regulate. I mean, there's this rigorous practice now of going down to the Titanic and removing pieces bit by bit and coming up, and they're being sold in the United States in second-hand shops, which I find close to being obscene. But it seems to be there's a kind of treaty which gives them authority to control matters, and the Titanic. I thought quite on the ocean floor in the high seas.
Yeah.
Can you explain that to me?
Maybe we can ask Livia.
Yes, absolutely.
Livia.
Can you hear me?
Yes.
Clear. Yeah.
Okay, perfect. Hello, everyone. It's nice to be there also without being there. So I would like to make a point, maybe in a preliminary way, because I also think, also not being an expert of the law of the sea, that it's pretty weird that the Italian courts have this kind of tradition of considering that, and it's part of the Code of Navigation, that whatever vessel or aircraft that is registered in Italy and flies the Italian flag is then an extension in international waters or in a space outside the jurisdiction of another country of the Italian state. But it's also a very a sort of consolidated approach, because in the Getty case, the Court of Cassation, because this is a case that lasted for over a decade. It was first brought in 2007, and then we had the final ruling of the Court of Cassation in 2019. And the Court of Cassation actually referred back to a case that was decided by a Sicilian tribunal, the Tribunal of Sciacca, that basically elaborated this approach regarding a bronze statuette that had been found by an Italian vessel in international waters. Once again, in that case, it was proved that the statuette was found in international waters. There was then an issue of who was the owner, whether it was the municipality, the actual fisherman that had found the statuette, or the Italian state. And basically, this was the argument that the court used in that situation to attribute ownership to the Italian state. And the statuette is currently in Palermo at the National Museum of Archaeology. So, and not in Sciacca, which is where the fisherman came from originally. So it's a very consolidated approach of the Italian courts. And in the Getty case, the European Court of Human Rights actually confirmed this approach. So they found it, now I don't have it with me exactly, but not manifestly contrary to the international law of the sea and customary international law. So in that sense, it was sanctioned by the European Courts of Human Rights. And then in terms of how to extend jurisdiction and how courts extend their national jurisdiction to their adjudicatory jurisdiction, of course, and then they apply their lex fori to shipwrecks or underwater cultural heritage that is situated in international waters, they use different arguments. And this is why we thought it was interesting to see the US and Italian approach, because the Italian approach we've seen was the Shaka approach. So whatever vessel flies an Italian flag is part of the Italian territory. But then the US approach was also quite interesting when it comes to the Titanic litigation, right? And in that case, that was framed in terms of salvage law, not underwater cultural heritage, because it was beyond the 3 miles that the Abandoned Shipwreck Act codifies. And in that sense, they actually ensure they recognize, they acknowledge their adjudicatory jurisdiction based on the idea that salvage law requires it, so that it's a principle of salvage law that would not be properly applied, that national courts, admiralty courts in this case, can extend their jurisdiction also to objects that are in international waters. Of course, problems then come to the surface when it comes to the enforcement jurisdiction of this course, because they do not have any. And in that case, we go back to the need for a cooperation system among different state actors, but also the cooperation with private actors when it comes to salvage law. So in this sense, that we observe this tendency to extend the adjudicatory jurisdiction without much concern for the enforcement. Now, depending on the approach of the specific state, the extension of adjudicatory jurisdiction might then bring an extension of cultural heritage law, meaning that automatically underwater cultural heritage is protected according to the same standards as territorial cultural heritage, or, as is the case with the US, it can lead to the extension of their maritime law, which I'm not an expert of, but then that's where potentially issues of protection come to the surface, because as we've seen, there is a clear tension between these two fields of law. I focused on the Italian cases, so I'm not aware of other, to answer to one of the questions that were posed, I do not have any knowledge of other cases concerning underwater cultural heritage, or more specifically, maritime archaeology, because then there's a lot of questions concerning shipwrecks, which are only one of the categories of underwater cultural heritage. But that has mostly to do with state vessels, right? And this is why we decided to introduce a final slide, a final caveat, let's say, that state immunity seems to be recognized by state courts, also when the national vessels or state-owned vessels are actually have sunken. So I hope this answers a bit or clarifies a bit.
The crucial issue here at the end of the day is whether the American courts will recognize the Italian judgment.
Indeed, this is why. Yeah.
They will not be party to the Convention of Human Rights. Yeah. And if I may, I don't believe this point, but we were talking about simple something. I mean, we're literally in the same realm, but in a different way. I'm sorry.
Yes, now Titanic, they have Americans have an interesting rule that if you bring piece of from the ship, you establish constructive jurisdiction, same as you boarded the vessel. You can do that under American laws. It's quite intrusive. My question is, it really law of salvage? If something happens on high sea, is it law of salvage or law of fines? Because for salvage, one of essential ingredients is danger.
Yeah.
But there is danger when there is something on the bottom of the sea.
Yeah.
It's dangerously go.
Yeah.
Well, I think it's danger by definition.
Yeah.
But it's yes, I was doing
Yeah, it can be safer on the bottom of the sea.
Yeah.
But it's very rare for it to be mid-Atlantic.
But I would say, from a salvage convention perspective, salvage is really about an emergency. But I read a book on by Professor Simon Wong from Swansea. He gave a definition of salvage law is considering
saving the property and finding the property. And maybe I'm wrong, but my understanding is under common law, a lot of fines can also be included in the word selfish law. Is this correct? My understanding?
Well, it's very well affirmative. Possession is 9/10 of the law.
And the problem is, if something is found on the high seas, nobody has jurisdiction. Because I think UNCLOS failed to address that. For the UNCLOS kept two provisions, 303 and 149, I believe, but they're very ambiguous.
Yeah.
And UNCLOS also, this convention also does not address jurisdiction in case of crisis. There is a gap now currently in law.
Yeah.
And problem is that's not solved. There's no also. I think that treasure hunters. They're not interested in history and civilization, interested in profit. They're interested in those goods, silver coins, gold coins, whatever. And sometimes they will use dynamic just to pick up those valuable goods.
Yeah.
And I'll give you opposite example. What should be done? If you go to Stockholm, there is Vasa Museum. Yes, and that's an example of what should be done to preserve these stories from history. And instead, there is still law that is favoring, I think Americans will never ratify this convention because most of these treasure hunters come from the streets in business. It's for money.
I think in the UK, in territorial waters, it's quite controlled. You can't do anything like this except under license. The other side of the coin is, and I'm not on the sides of the landlords, but they have the technology and the determination to do it. And therefore, it might be wise not to work together with them.
Yeah.
If you take the silver, and Saros, and that was a major operation for years, and millions of investment in. They could have lifted that silver and just taken it wherever they wished.
Yeah.
But they worked with cooperation with South Africa. Everything was huge, and the only thing they did, once they got the silver out, they got it to the UK in the cover of night. That was very well conceived. But for the reason they were taking into an admiralty jurisdiction where everything was on. And in any event, that was all theory, but they came to agree South Africa. But it's I think if you work on the license, obviously everything you take out of the solve the major what happened.
Yeah.
So
Yeah, I totally agree with you, Professor Thomas. I think we have to work with those treasure hunters in order to give the market a chance to solve the problem. If we just say ban everything, my co-author will probably agree that she won't ban treasure hunter. but who would actually make investments and develop a technology to actually do it? Can we really rely on governments on this sort of job? I mean, even for environmental salvage, we cannot solely rely on coastal guards. We have to engage with commercial investment in salvage industry. For treasure hunting, I would also say we have to encourage them to.
It can be controlled.
Yeah, but that's the problem.
Then they can sell.
Yeah.
The money.
Yeah.
Not, they would not bring it to museum. They would sell it for the money. That's what they do.
Yeah.
To add additional legal complication under UNCLOS, actually, seabed of the high seas is not anymore high sea, right, Nitya? Under Part 11, it's international seabed area under the seabed authority in Kingston, Jamaica. So it's additional, but it has authority the extraction of the minerals from the seabed.
I'm not sure whether it's big about also.
Yeah.
Yes, but I think back.
But I think both in the EEZ and the area, seabed, neither the coastal state nor the International Seabed Authority has jurisdiction over shipwrecks. It talks about natural resources in the seabed, like either living or non-shipwrecking. So obviously artifacts.
Yes, but UNESCO Convention 2001 explicitly says jurisdiction concerning the cultural heritage is extended in the EEZ.
Okay.
Okay?
Yes,
And,
yes.
and speaks about contiguous zone, also adding something which wasn't in the 58 Geneva Convention of Territorial Sea and Contiguous Zone. It was only control in respect of the violation of customs, immigrants, and tax regulations, and UNCLOS add protection of underwater heritage in contiguous zone, which means 24 miles from the basement. And this UNESCO convention goes until 200 miles. So EEZ would be covered, but then we have to look. I'm just looking at the states parties of the UNESCO convention, and I see that well, a lot of European, Mediterranean, and other states are parties. So Italy, France, Spain, Portugal, Belgium, Croatia, Bosnia, Montenegro, Albania, and many other countries. So they are state parties. US, unfortunately, not. Mexico is a party, and Argentina.
Yeah, I noticed that most of those members of the convention, they are not common law jurisdictions, and they are also not original countries where the statute they have the interest in taking on the cultural heritage because originally it's from their land, I guess. And for US, they are the market nations. They are actually dealing it. Maybe it's better to protect it that way, but they are a business on their territory. So that might be a coincidence, but quite interesting. Sorry.
I just wanted to say, for the entering force of the UNESCO Convention, it was quite dubious because certain states, they extend the jurisdiction of underwater cultural heritage also within their exclusive EEZ beyond the limits of the contiguous zone. And this was something really which was not, let's say, 100% true because the UNESCO Convention does not give, let's say, jurisdiction over underwater historical heritage to a coastal state within its EEZ. This was solved to a certain extent with the entry into force of.
Can we discuss it maybe with Professor Scovazzi, or do you have any?
Yes, I think that was the case with Italy because maybe our colleague to confirm this. I'm not quite sure, but I think that within the Italian ecological zone, the jurisdiction extended also, let's say, beyond the 24 nautical miles. And this even before the entry into force of the UNESCO Convention. That was one case which was, let's say, interesting from, let's say, at least from the academic point of view.
Okay, I think we can conclude this topic. Thank you, Haiyang.
Thank you.